I'm Jaclyn Robertson with JR Law Group, and welcome to Family Law Friday. This week we're talking about alimony. This is a big issue. It's ripe with controversy and can lead to multiple areas of litigation, but it doesn't have to be that complicated and or something that you run from divorce because of. Seriously, some clients come to me and they're so overwhelmed by, will I be able to get alimony? How much will I owe? That they're really teeter on just not even being willing to do what's best for them because of this fearful piece, alimony. So first of all, alimony is more complex and nuanced than child support. Child support is just each party's income and run through the calculator. Alimony is a much more ambiguous process that needs to be addressed, and there's things that need to be done to arrive at an understanding of what a fair alimony amount will be. So the first thing is alimony, either spouse could potentially be the payor or recipient. And generally during the course of a marriage, possibly in some cases one party may have been the primary breadwinner and the other party may have been running the household and children and taking care of other functions, or there's situations where both parties worked but one had significantly more income. And so the very first piece to look at in alimony is, what is the potential recipient party's financial need? Now, the financial need is going to be determined by looking at an itemized list of their monthly expenses. Alimony is separate from the division of the marital estate and any, cash or other assets each party may have split equally. It turns on each party's monthly expenses, and it will turn on the payor spouse will be paying a X amount each month based off their respective monthly income. So the first piece is to look at the party's monthly expenses. Now, we talked before on the financial declaration, and at the last part of the financial declaration is where you itemize your current monthly expenses. So from there, you have a general idea of what your budget is, and this is basically what your financial need is. However, you then also turn to, what is the recipient spouse being the one who will receive the alimony, what is their ability to meet their own financial need? So if you are receiving child support as a recipient spouse, that will be a sum that's deducted from the monthly expenses. Also, what is the recipient spouse's ability to earn their own monthly income? So generally speaking, you will look at what their skill set is, education, history of employment is. If this is someone who has been not in the workforce for several years and has been home with the children, then at a minimum, they will be imputed at the rate of minimum wage, 40 hours a week. That's the general rule of thumb. In some cases, if there are, for example, if there are cases involving small children, then potentially the cost of childcare could exceed what that recipient spouse could earn. That will be one rare occasion where the recipient spouse won't be imputed in income. So imputed means that the amount the recipient spouse should, could, will earn, regardless of whether or not they're technically currently employed. So again, that'll be at the rate of minimum wage, 40 hours a week, in a scenario of someone that's been out of the workforce for a long time and potentially not having any specialized skill or higher level of education. So that number, their income that they've been imputed or that they earn or are capable of earning, as well as child support, will be deducted from the monthly expense amount. So once you deduct those two numbers, you're left with potentially an amount. And that remaining amount is what we assert as their financial need that you then turn to the payor spouse. Now, the payor spouse also gets to factor in what their financial expenses are each month, because the question, once you've evaluated what the recipient spouse's need is, you look at the payor spouse's ability to pay. So that factors in, okay, they have this amount coming in with their employment each month, but they also have monthly expenses, which they will also have outlined. So you then look at that. If there's a surplus once they've met their monthly expenses, then it's going to be easy to take that money and say, okay, that's what you're going to pay in alimony, amounting to the extent possible, the recipient spouse's leftover financial need or required assistance. Now, in cases where both parties have asserted their expenses and they've come up with a number, if the payor spouse is still coming up short in the ability to meet the recipient spouse's need, meaning there's a shortfall. Divorce can be costly in the sense that you're dividing households. You both will have, a rental or mortgage payment. You both have your fixed monthly expenses. So if there's a shortfall, the courts will oftentimes go through a process of what's called income equalization. And that means you look at each other's expenses and so there's a shortfall in what the payer spouse can provide, we look at making so you just basically split the difference and put both parties living off of the same amount each month, and it's then up to them both to turn towards their asserted expenses and cut costs as they need to, because the piece in alimony that's also important is the payer spouse's ability to pay. So that's income equalization. Now, in cases where the payer spouse may potentially have far more income coming in, then they will easily be able to meet that asserted need. But then it's also, if they do earn a lot more money than what the asserted financial need is, it doesn't necessarily and generally is not something that you just automatically go to income equalization, meaning both parties will be equally split. You then look at what is the standard of living the parties enjoyed during the course of the marriage. Now, some people have come to me saying, well, my standard of living during the marriage was to not work. That is not how the courts look at standard of living. Standard of living does not mean because you enjoyed the privilege of not working for several years. Some people call it a privilege. I say that because that's what I've heard. But if you had that liberty and you didn't need to work and you didn't work, that does not mean you will not be imputed an income. The court will still look at what is your ability to earn a living, and they're going to impute an income to you based on your skill set at a minimum, generally minimum wage, full time. Standard of living means looking at each party's expenses. What are some reasonable extra expenses you are asserting? If these are reasonable expenses that you enjoyed throughout the duration of the marriage, then that's going to be reasonable for you to assert these expenses. And you can then turn to the payer spouse for a higher alimony claim. But that again doesn't mean income neutralization, equalization. It just means you're probably going to get a higher alimony claim. And it looks at what your lifestyle was during the marriage, not by the time this case ultimately goes to trial. Because by then you've divided households. A lot of times parties are required to live at a lesser standard of living for a period as they adjust and transition into post-divorce life. So that generally in a nutshell is alimony. What is the recipient spouse's need? And you look at the payer's ability to pay. So a lot of clients have come to me fearful, am I going to have to pay this much every month? And I'm happy to explain to them, again, it's a court of equity, and sure, you, if you've been the breadwinner, may have a duty to pay alimony. However, it's based in equity. You still have financial needs as well. And so the recipient spouse is not going to be able to just take all of your money and make it so that you yourself can't afford to live either. It's, again, based on an equitable process of looking at what's a fair division of each party's income. Another big piece of alimony is how long are you going to have to pay alimony, or will you receive alimony? Now, first up, the duration of the marriage is a factor to consider in terms of whether or not you will even owe alimony. So general rule of thumb, marriages that are of 3 years or less duration, the courts have generally opted to say this is very short. Neither of you have been truly dependent, and you should both go your respective ways with your own respective earning capacity as you were when you entered the marriage. Now, as you progress beyond 3 years, you're looking more at a reasonable alimony claim, especially if one of the spouses has given up their career to stay with children. That's definitely a factor. So then the longer the marriage, the more likely the alimony claim. And then there are different trends in alimony between, sometimes parties have sought alimony for the full term of the marriage. Other alimony claims have been based on a rehabilitative period, meaning potentially a recipient spouse has specialized skill and training and an ability to earn a living. However, if they've stayed home for the duration of the marriage, they need a few years to get on their feet, and so that would be called rehabilitative alimony, and that is generally more likely to be about half the length of the marriage. So if you were married 10 years, you're looking at potentially a 5-year alimony claim. Now, the statutes specifically outline different factors that will impact alimony and whether or not you should receive it and for how long and the amounts. The general rule of thumb, though, the longer you've been married and the longer you've been financially dependent on the payer spouse, the more likely you are to get alimony and the more likely it is to be a more long-term, more closer to the length of the marriage. And especially if this is a divorce happening at later stages of life where your chances of getting your own education, getting your own career back on track are less, then you're going to be looking at a reasonable, longer-termed alimony claim. So your attorney will help you go through each of the factors to fully flesh out, but that's the general idea. So the alimony claim and the duration of it will turn on the length of your marriage and what your status was during the marriage. And so that is a general outline of alimony. Again, this is far less clear cut. There's a ton of factors that can come into play that your attorney will help you with, who will have the expertise to focus on the issues that will help you and kind of help you understand the pieces that will not impact your alimony claim or your alimony obligation. Also, coming up in 2019, there's a big tax law change that will impact whether or not, if you are paying alimony, what your tax burden is and whether or not you can claim it as a write-off. And that's what we're going to talk about next week. So if you'd like to schedule a consultation to talk more specifically about your case, go to my website at jrlawgroup.com and schedule a consultation. Otherwise, follow me on Instagram at jrlawgroup, and I'll see you next Family Law Friday.